for your different classes. So I think it's an enormous amount of people that are interested in the topic and in your opinion on the topic. So congratulations for.
Well, that is. Thank you for telling me. I am very. It's not. I'm shocked. I'm delighted, but I'm very, very amazed, because that is a lot of people. That is many, many, many people. You know, I mean, that's a big attendance.
And they come from all over Europe, which is nice, because it's ULB students, but also very different participants. And I think it's really because they wanted to listen to you. So
I am pleased and embarrassed in about equal quantity. Okay, let me just put this so that it's up as it should. 619, because I'm taking stuff off the screen here at the same time. Right, I'm ready. If other people,
yeah,
if you're
people
ready.
are connected, and I just add that when you interact and you speak with Eleanor Sharpston, please introduce yourself before speaking, because we do have students and other people, external judges and other, so it's easier for Professor Eleanor Sharpston to know who is speaking and to react knowing that. So thank you for respecting this before speaking.
Thank you very much. Ladies and gentlemen, good morning. Before I move on to today, I should say that at the end of yesterday, when we were talking about the rule of law and the terrorist suspect, I made a mention in my handout, but I didn't actually do the little publicity on live for you. I mentioned an excellent doctoral thesis where I just had the pleasure of being part of the jury for examining the thesis. An excellent doctoral thesis by Elodie Sellier called Coherence in EU Counterterrorism. Doctor, as she now is, Dr. Sellier did her studies at ULB, and the thesis is here. The details of the thesis are in the handout, and if you are interested in what I was talking about yesterday, I do commend it as being obviously very up to date, but also very, very thorough and very thought-provoking for that particular area of the law. So let us move on to today, to this final session, and let me do with you what I have described as a shared exploration. And I put down 4 aspects of the shared exploration. Why does judicial independence matter? How does judicial independence manifest itself? Are the downsides, that's to say, are the negative things to judicial independence as well as positive things? And if you reach the conclusion that you think that it's a good idea that there should be judicial independence, what are the elements that you would put into a system in order to promote judicial independence, in order to encourage the judges to be independent? How would you design your system in order to foster judicial independence? And so please, as usual, I have a nice clean piece of paper, and I would be very interested to have your contributions. Allez-y. Soit en anglais, soit en français, ça m'est absolument égal. Comme vous avez peut-être pu maintenant constater, vraiment, cela m'est égal, n'est-ce pas?
So I'm looking at the hands raised. Who wants to comment on this or to contribute?
Come on, somebody.
Always difficult to start.
Courage.
Moi, je crois que Sébastien Williams va être notre candidat.
Ah,
oui?
mais il est très gentil, Sébastien. Il est prêt pour s'intervenir, ça c'est très bien.
Merci.
Allez-y, Sébastien, je vous en prie. Go ahead.
Thank you very much. So in my opinion, the judicial independence is embedded in the rule of law in regards to the way that our rights in the EU are protected because of the fact that the judicial power is independent. We can look, for example, at countries such as Poland, which these past few years have demonstrated a disregard to the judicial independence and how it can affect rights such as, for example, LGBTQIA plus rights. This is a good example of how, in a certain way, the judicial independence can, when it is damaged, can actually show an infringement of our rights as European citizens. So I would say that it is very much important in regards to the rule of law because of the infringements of rights themselves.
Thank you. That's got us going nicely. Other people, please.
Other people, we are waiting for your hands or your comments on the chat box. You know that we may... Anna Paula, yes, you're welcome.
Yeah.
It's a bit odd for me to say that, but judicial independence is all my work, and we cannot apply the law if we are not independent, if we are afraid. We cannot deal impartially with the issues and solve the problems of the other people if we are not free. And if we cannot think freely and do what appears to us to be right. Maybe we are wrong, and sometimes we are wrong, but people come to court in order to get their problems solved according to law and with no other barrier than what appears to be right, even if it isn't. But it's if we cannot be, if we have to think if we are going to be punished or dismissed or in some way have some problem with the decision, we are not free to take the right decision. So it's not a decision according to law at all.
That is, if I may respectfully say, an enormously important contribution, because unless your judge is not under pressure of some kind, we might talk about what kinds of pressure there might be on a judge, but unless your judge is free from pressure, how can your judge in fact act impartially and decide impartially? Very, very, very important point.
Because judges are only people, and we are afraid of lots of things like other citizens. So it's very important that we have some peace and independence, and we are not afraid of being in some kind, have a punishment for doing, or we have to be just heroes, and we are just people, we are not heroes.
We cannot require that every judge should be a hero.
Yes.
Sometimes we are lucky and we see that there are judges who really are heroes and they're wonderful, but we cannot require of people that just to do their job correctly, they should be heroes. That is putting a too high a requirement. What do people think? What do people think would be elements, therefore, that we need to have in place in order to make sure that the judges can be independent? What do we need to have as parts of the system?
Alors, je me retourne vers les mains levées. N'hésitez pas à prendre la parole. Alors, oui, Anna Paula, mais je crois que c'est une ancienne main. Est-ce qu'il y a d'autres étudiants? Je pense que là, quand même, on a abordé ces questions dans différents cours. Vous devriez tous, et il n'y a pas de fausses réponses, c'est des idées que vous avez, et après, on verra bien comment ça peut être synthétisé et relié avec ce qui existe, mais donc ne soyez pas timide. Kadiatou, vous travaillez sur ces questions pour votre TFE. Est-ce que vous avez des idées?
Donc, c'est quels éléments permettent d'encourager l'indépendance de la justice?
Donc, à partir du moment où on pense que c'est important que les juges soient indépendants, qu'est-ce qu'on doit mettre en place dans le système pour que cette indépendance soit garantie? Qu'est-ce qui peut aider à cette indépendance?
Je pense déjà que la séparation des pouvoirs permet déjà de montrer qu'il y a une certaine indépendance vis-à-vis des autres pouvoirs, donc législatifs et exécutifs. Et je pense qu'un juge doit, comment dire, il faut que ça soit aussi prévu dans une constitution ou dans un acte, une loi plutôt, pour permettre, pour encourager et pour mettre un cadre autour de cette indépendance.
Vous pensez à quoi comme cadre? Quels sont les éléments pour encadrer cette indépendance? Quelles sont les garanties qu'on devrait mettre en place pour protéger alors notre juge? Pour que, comme disait Madame la juge Anna Paula tout à l'heure, pour que ce ne soit pas nécessaire que tous nos juges soient des héros, mais pour que tout simplement nos juges puissent travailler dans la paix et dans du calme. Qu'est-ce qu'on doit mettre en place?
On doit leur reconnaître une impartialité et oui, c'est vraiment reconnaître leur indépendance et reconnaître qu'ils sont des acteurs de la justice et pas seulement des acteurs qui parlent au nom de la loi, mais plutôt qui interprètent la loi.
Bon, j'ai dans le chat, j'ai quelqu'un qui a gentiment nomination à vie pour qu'il n'ait pas peur d'être démis. Hein, et ça, c'est déjà un point important. Merci à la personne qui a mis ça dans le chat. Je pourrais poser la question, supposons que nous ne payons nos juges qu'un salaire vraiment minable. On va leur payer 20 € par jour. Est-ce que ça va protéger l'indépendance du juge?
Alors, Eleanor, tout à coup, il y a plusieurs personnes qui demandent la parole. Donc, il y a Rifou.
C'est très bien. C'est très bien.
D'abord. Rifou, vous m'entendez?
Oui, excusez-moi.
Oui.
Allez-y, mais un peu plus fort, s'il vous plaît.
Okay, donc I thought about two other things. I thought about salary. I don't know how you say that in English, but
you said it fine. I've written down the word salary, and indeed that relates to the bad example I just gave, because if we pay them 20 euros a day, they're not going to be able to be financially independent, right? Yeah. And they are going to be very open to corruption because the poor guys have got to live. So salary, very important point. Yes. Your second point, that was a good point.
And another point was if the decisions are going to be when there is an appeal or yes, to change the decision of a judge, the judge who had made a wrong decision or a decision that is reversed shouldn't be sanctioned because he didn't do what the higher judge did. And the sanctions should be, for the next time you should apply better the law, but not like a financial sanction or humiliate him because he didn't do what the higher judge did. That's what I think.
Right. let me ask the question. Supposing a judge makes 20 judgments, and one of those judgments is changed by the Court of Appeal, and the other 19, the Court of Appeal says, no, he was right. Is there, should he even be told to apply the law better? Do you see what I mean? If he makes one or two judgments, he or she makes one or two judgments that are, quotes, wrong, close quotes, should somebody be saying to him, no punishment, but you should apply the law better? Should they even say that to him?
No.
I mean, if he makes 20 judgments and they're all overturned, that may be different, yeah?
Yes, of course. I think that it's a question of proportion, and it's when there are too much judgment that are not according to the higher courts. He should or she should change the way she views law. But in other cases, when there is one or two judgment that are reversed, I don't think that it should change. It's just that he have a different opinion on certain point. Yes.
Well, I agree with you absolutely, in the sense that both you can have different opinions. I mean, we are all lawyers. We can have different opinions about what should be the answer in a particular case. And also, you know something, as Judge Anna Paula said, we are also all human beings, right? We can all sometimes make a wrong decision, but you have to be able to make the decision knowing that there is not a sword hanging over your head, you know, that if you make a wrong decision, that's the end of your career, because you can't be free to decide if you have that pressure on you. So we have independence, we have salary, we have no punishment if your decision is wrong. We have the length of your nomination.
Eleanor, if I may, there's still Sybil Top and Sebastian Williams that want to intervene.
Allez-y.
Sybil Top.
Hello.
Yeah.
Can you hear me?
Yes.
If you speak a bit louder, yes.
Okay, no problem.
Thank you.
I know that of course, there's the obvious answer of insulating as much as possible the judiciary from the political world, I would say, but also concerning the appointment of judges, I would say avoid as much as possible revolving doors between the political world and the judiciary. And I feel like, especially at the highest levels in constitutional courts and at those levels, it's usually the judges are sometimes, not usually, okay, I'm using maybe a big word here, but the judges are sometimes appointed or appointed by the executive power. And that would be, I mean, I can see the advantages, but you can also see where this could be problematic in terms of independence of the judiciary.
Mm-hmm. Again, a very helpful contribution. By the way, somebody's got to do the appointment, right?
Yeah.
How are we going to do the appointment process? Are they judges going to have to be vetted by Parliament, or are they going to be appointed by the executive? I mean, somebody's got to make the appointment. Or does it not matter exactly how the appointment's made, providing the judge is independent afterwards? Or, you know, what do you think?
They could be, there could be names put forward by their peers, so from within the judiciary, and indeed then have, of course, a validation procedure that, or something like that, that could be validated by the Parliament. I'm not sure. I won't make any.
No, but I was asking you because you know there's an issue there which your contribution helpfully enabled me to expand on. Thank you for that. There's two more. I see two more hands. Yes,
Sebastian.
Well, thank you. My contribution was going to be exactly the question of the who is going to appoint the nomination, but I had some sort of question while my colleague was speaking, and in a certain way, can we consider that maybe the independence of the judge, even though the judge has been appointed by the executive power with the view of the parliament, can be maybe still still okay in regards with the independence of the judge if the length of the nomination itself is an appointment for life, and in that perspective, if the judge is appointed for life, well, even though the executive power will appoint the judge, the nominee judge, then the fact that the judge itself, if he becomes a judge, will be appointed for life, and so the political influence that the executive power could have had will not be efficient because of the fact that the judge itself,
because it's an appointment for life. That's a very useful point. Again, I would mention here, just for you to think about, if you look at the procedure for the Strasbourg court and the procedure for the courts, both courts in Luxembourg, the Strasbourg court, it is a single mandate, which is not renewable, which is a 9-year mandate. And so you could say once the judge is appointed, the judge, it may be a slightly political process to get appointed, but once you are appointed, you actually are really independent because you know you can't be reappointed, but you also know you have a 9-year mandate. The process in the Luxembourg courts, they are shorter mandates, they are 6-year mandates, and they are renewable mandates. And so you could make the argument, I've heard it made indeed, that may cause a bit of a problem because as the judge comes towards the end of their mandate, they're hoping that they're going to get put forward again by their member state. And that's all very well, but what does that do to judicial independence? By the way, if that's true, if that question mark is raised about the judges, it should logically be raised about the advocates general who are on the big member state posts. I don't know if you know this, but the advocates general at the court, of the 11 advocates general, what was 6 and what is now 5 big member states have, there's a political agreement. This is not law. This is a political agreement. The big member states, 5 big member states, Germany, France, Italy, Spain, and Poland, have a permanent right to put forward somebody to be an advocate general. And so if you are an advocate general from one of those member states, you can be reappointed. If you're an advocate general from a smaller member state, you only get one 6-year mandate, and then it is the turn of a different member state to put their candidate forward. But given that the advocate general literally gives a personal opinion, which they sign, which is up on the internet, unlike the judges, you know exactly what the advocate general thinks because there is the text with their signature underneath it. Whereas the judge is to some degree protected by the secret du délibéré. It's a single judgment in Luxembourg, and all the judges sign the judgment. And so, you can't tell, looking at the judgment from the outside, who was in agreement, who was in disagreement with the result that is there. So again, the identifiability of the judge, and whether you can actually see what they decided, or whether they are in some way protected by being in a collegiate court, is maybe also an element in there. I was going to add to this listing, we have different ways of having judges. In the common law tradition, the judiciary comes from practitioners mainly. So somebody can spend 20 years arguing one side of a case, and then they become a judge. And so then they look at both sides of the case. You can ask, do they know how to look at both sides of the case? You can also say, well, they must, because otherwise they wouldn't have been a very good practitioner. And you can also say, actually they probably know all the tricks because they did some of the tricks themselves. So they have a lot of practical kind of street experience, which a young career judge aged 25 has just finished their judicial training. By definition, they're not going to have that experience. I mean, they couldn't possibly, however brilliant they are, they could not actually have that experience. So again, there are all sorts of elements that are going to come into this equation. There is still a hand that I see there. Two hands. I will shut up. Why don't you please give your contributions? Il y a encore des contributions à ce que je vois.
Je ne suis pas sûre. Est-ce que Anna Paula, vous vouliez, you wanted to?
Non, il y a des mains. Moi, je vois des mains.
Top, she already spoke.
I don't want to keep on speaking, but something that I experience and that concerns much independence in my point of view is nowadays, and we have lots and lots of issues, of technical issues to deal with, and the preparation for dealing with that has a lot to do with the decision. If we don't have a staff prepared, we cannot know technology, science, medicine in a specific issue, and sometimes it's very difficult to be impartial if we don't know enough. If we don't, and if we cannot support enough in independent scientists and technicians.
Okay, that's I think also a very important point. Your judge needs some support. Your judge needs support in terms of resources, in terms of being given the time to study the files. We haven't mentioned time yet, but if you say to your judge, you are meant to decide 20 cases every day, how is your judge actually going to be able to look at the cases and absorb what they're about and reflect before deciding? So I've deliberately let this discussion run because I wanted you to think about what are the elements that go into having an independent judiciary. It is one thing to say, let's have an independent judiciary, right? It is another thing to say, yeah, how do we actually do that? And at this stage, I want to link on to a question that was given to me yesterday, that was sent to me yesterday by Kadiatu Kardian. Je me pose la question de la liberté d'expression des magistrats. Pensez-vous que la liberté d'expression des magistrats, celle que décrite et affirmée par la CEDH dans l'affaire Baca contre Hongrois, respecte le principe de l'impartialité des juges? Est-ce que les juges doivent être considérés comme des interprètes du droit, même dans le cadre de leur fonction? Ou bien faut-il tout de même respecter un certain devoir de réserve, vu que les juges, s'exprimant dans des discours officiels, s'expriment finalement en tant que représentants de leur organe? Est-ce que la confiance des citoyens dans le système judiciaire pourrait être amoindrie avec cette liberté d'expression des magistrats plus forte? And it's a very helpful question because it sent me back to read Baca and Hungary against Hungary, both in the section and in the Grand Chamber, and that is always important, to be sent back to read the case law. It's a fair question, but I think the answer to it has to begin by saying we should look at what Mr. Baca, who was at that point the president of the Supreme Court, we should look at what he was actually saying, all right? Because liberté d'expression in the abstract is one thing, but let's look at what he was actually talking about. And we find that at paragraph 145 of the Grand Chamber judgment, because I went back and read it. Okay, what is he saying? He was in his professional capacity as president of the Supreme Court and also president of the National Council of Justice. So he had a big double job, right? He publicly expressed his views on various legislative reforms affecting the judiciary. And then there's a list in that paragraph 145, there is a list of his interventions. He had 7 interventions. His spokesperson explained to a newspaper his concern about a bill that ordered the annulment of final convictions. He gave a speech in Parliament on certain aspects of the draft version of the new fundamental law, that's the new constitution. With other court presidents, he sent a letter to the President of the Republic and the Prime Minister where they criticized the proposal in the draft version of the fundamental law of Hungary to reduce the mandatory retirement age of judges. He sent another letter to the Prime Minister in which he again criticized that proposal, and he said the proposal is humiliating and it infringes the principles of the independence and the irremovability of judges. And then there was another public communique with the plenary of the Supreme Court, so with all his colleagues in the Supreme Court and the presidents of other courts. There was a public communique criticized the new retirement age for judges, and they were wondering whether there was some political motivation going on behind this. Then he challenged new legislation on judicial proceedings before the Constitutional Court. And finally, he gave another speech before Parliament in which he said that he had concern about replacing the National Council of Justice by an external administration called the National Judicial Office. And he said, I criticize this proposal. The new body would have excessive, unconstitutional and uncontrollable powers. And he criticized the new retirement age for judges and said it would have a severe effect on the Supreme Court. So absolutely, he said lots of things, right? That's for sure. If you look at what he was saying, the things he was saying were all things that really, I think, fell within the scope of what he could and indeed probably should comment on as the president of the Supreme Court and as the president of the National Council of Justice. Because those things that he was commenting on were all things about the way the judicial system was being amended and changed in Hungary. And sometimes he was speaking indeed with lots of his colleagues, and sometimes he was speaking on his own. He was not expressing views about, for example, changing the criminal law so that something was or wasn't an offence. He wasn't expressing views about any case in which he was or might become involved. All right, I think those statements are important because the devoir de réserve, which you mentioned, is, I would agree, very important. But to me, the devoir de réserve relates to, for example, not making political interventions. It relates to not interfering with the way a case is being handled by another judge or another court. It relates to not commenting on what has happened in the délibéré, right? But none of that was he doing. What he was doing was making statements in his capacity as president of the Supreme Court and president of the National Council of the Judiciary. And, you know, selon moi, he was absolutely entitled to make those statements. One might indeed almost say he was required to make his views known. And I think here of statements that have been made in the UK by, for example, the Lord Chief Justice or the President of the Supreme Court, when there have been moves about changing things structurally in the way the judiciary is run. And they've said, well, you know, we welcome that change. Or they say, oh, I'm not so sure about that. Would you like to go and think about that a bit more? Yeah, that seems to me to be legitimate commentary. So I would agree with the Grand Chamber, respectfully, that it absolutely comes under freedom of expression under Article 10 ECHR. And I would also respectfully agree with them that if the result of somebody making those comments is that they find that their mandate as president of the Supreme Court is curtailed, something went wrong, right? Because that's indeed what happened with Mr. Bakker. And that is why Mr. Bakker's case is not only about Article 10, but it's also about the fact that he had no way of challenging the fact that he ceased to be president of the Supreme Court. But thank you. As you see, your question was a very useful question because it enabled us also to bring into the discussion the element of how far the judge can comment and how far the judge has a devoir de réserve. I would like to mention, I'm looking at my timing, and I am going to mention shorter rather than longer. I am going to talk, if I were talking, I need to mention both Juízes Portugueses and Commission on Poland. The essential element in Juízes Portugueses is the cases brought by the Associação Sindical dos Juízes Portugueses and the Tribunal de Contas. And the litigation is between those two because there is a temporary reduction in the amount of remuneration paid to the members of the court. And that is in the context of the Portuguese state's budgetary policy guidelines. And this is, of course, all against the background of big financial issues I don't need to go into. So it's a temporary reduction. Shall we say that it is not entirely unassociated with the things that are happening at EU level to support for Portugal. The law applied to lots and lots and lots and lots of people. Paragraph 9 of the judgment in this case, in case 6416, sets out the persons to whom the office holders to whom this law applies, and the list starts with the President of the Republic. It covers all the members of the Assembleia da República. It covers judges, the Attorney General, prosecutors, judges of administrative and tribunal, representatives of the Republic for the autonomous regions, the various deputies of the Assembleias Legislativas das Regiões Autónomas. I hope Judge Ana Paula will forgive my Brazilian accent there. It covers lots of public administrators, lots of employees performing public duties. In other words, this is an enormously wide sweeping measure. It is not a measure that just targets the judges. I think that point is actually very important. You know, this is a big economy-wide measure that affects people who are in the public service in the broadest sense. And the question that was referred by the Supreme Administrative Court was, in view of the mandatory requirements of eliminating the excessive budget deficit and of financial assistance regulated by rules of EU law, must the principle of judicial independence enshrined in the second subparagraph of Article 19, para 1 TEU, Article 47 of the Charter, and in the case law of the Court of Justice, be interpreted as meaning that it precludes the measures to reduce remuneration that are applied to the judiciary in Portugal when they are imposed unilaterally and on an ongoing basis by other constitutional authorities and bodies. Now, in this judgment, the answer at the end of the story is no, this is all right. This is permissible. In the process of saying this is permissible, the court said a lot of very important things about making sure that the bodies which as courts or tribunal within the meaning of EU law come within the judicial system in the fields covered by EU law, that those bodies meet the requirements of effective judicial protection. And the court has a lot of strong statements to make about the guarantee of independence. This is paragraphs 42 and following. The guarantee of independence that is required not only at EU level as regards the judges of the Union and the Advocates General of the Court of Justice, but also at the level of the member states as regards national courts. And then they examine what is actually happening here, and they say, you know, all right, having receipt of remuneration commensurate with the importance of the functions carried out constitutes a guarantee essential to judicial independence. Now let's look at what's actually being done. This is not a measure that is targeted at the judiciary. It's not targeted at the members of the Tribunal de Contas. It is part of general measures seeking a contribution. This is at paragraph 49. General measures seeking a contribution from all members of the national public administration to the austerity effort dictated by the mandatory requirements for reducing the Portuguese state's excessive budget deficit. So it's not targeted at the judges, and it's temporary. It's part of general measures. In those circumstances, the answer to the question is that those provisions of EU law cited, the principle of judicial independence, does not preclude general salary reduction measures, such as those at issue in the main proceedings, linked to requirements to eliminate an excessive budget deficit and to an EU financial assistance programme from being applied. So, big statements about the importance of judicial independence, but because these were generalised measures and because they were temporary, they were acceptable. Go across from there, if you will. There are a lot of cases currently or recently being decided or recently decided in relation to what is happening in Poland. I've pulled out for you the Grand Chamber decision in case C61918, Commission against Poland. And I've pulled that out because that has got some of the big statements. It cites obviously Associação Sindical dos Juízes Portugueses, but it has more big statements about the requirement that the courts be independent. These are the passages that are found at paragraph 71 and following of the judgment. The court says the requirement that courts be independent, which member states must ensure is observed in respect of courts that are called upon to rule on issues linked to the interpretation and application of EU law. That has two aspects to it. There's an external aspect, which requires that the court concerned exercise its function wholly autonomously, without being subject to any hierarchical constraint or subordinated to any other body, and without taking orders or instructions from any source whatsoever. It has to be protected against external pressure to impair the independent judgment of its members and influence their decisions. Then there's an internal aspect which is linked to impartiality, distance from the parties, objectivity, absence of any interest in the outcome of the proceedings, apart from the strict application of the rule of law. And then the court goes on to say what those guarantees of independence and impartiality actually require. They require, this is paragraph 74, they require rules, particularly as regards the composition of the body and the appointment, length of service, and grounds for abstention, rejection, and dismissal of its members. Rules that are such as to dispel any reasonable doubt in the minds of individuals as to the imperviousness of that body to external factors and its neutrality with respect to the interest before it. So there have to be guarantees for the individuals who adjudicate. There have to be, and again I quote from the judgment, guarantees against removal from office. The principle of irremovability requires in particular that judges may remain in post provided that they have not reached the obligatory retirement age or until the expiry of their mandate, where that mandate is for a fixed term. While it is not wholly absolute, there can be no exceptions to that principle unless they are warranted by legitimate and compelling grounds subject to the principle of proportionality. And it goes on thus, it's widely accepted you can dismiss judges if they're deemed unfit for the purposes of carrying out their duties on account of incapacity or a serious breach of their obligations, providing the appropriate procedures are followed. So very, very, very strong statements about the importance of underpinning independence and impartiality by having rules that say these judges, once appointed, cannot be, for example, removed at will. The principle of irremovability is not absolute, but there has to be a very good reason for removing a judge, and the reason has to be warranted by compelling, legitimate and compelling grounds and subject to the principle of proportionality. Otherwise, you should not remove a judge who has a fixed term mandate from office. Thus says the Grand Chamber. And for that reason, indeed, when you go through to the end of the judgment and you look at the analysis of the measure lowering the retirement age of the Supreme Court judges, they say that the application of the measure is not justified by a legitimate objective, and the judgment concludes that by providing that the measure lowering the retirement ages of the judges is to apply to judges in post who were appointed before April 2018, and secondly, by granting the President of the Republic the discretion to extend the period of judicial activity of the judges of that court beyond the newly fixed retirement age, Poland has failed to fulfill its obligations. So it's a very clear, very strong judgment upholding the independence of the judiciary. I'm going to mention, before the break, I'm going to mention one more case, which is a very recent decision of the European Court of Human Rights. And I say recent, the judgment came out on the 9th of March 2021. This is a recent judgment. It's the case of Bilgen against Turkey. And the basic point is that Mr. Bilgen was transferred from the court in which he was serving to another less prestigious court, and there was no way that he could get that decision to transfer him, which was made for reasons we can perhaps guess at. There was no way he could actually get a review by a court of that decision. And I have pulled out from that judgment a couple of passages. Actually, a lot of the judgment discusses admissibility, and within that discussion, there is at paragraph 56, there is the following statement: given the prominent place that the judiciary occupies among state organs in a democratic society and the growing importance attached to the separation of powers and to the necessity of safeguarding the independence of the judiciary, and there's a reference to an earlier case, another case just decided, Ramos Nunes de Carvalho against Portugal, decided in the Grand Chamber, the court must be particularly attentive to the protection of members of the judiciary against measures affecting their status or career that can threaten their judicial independence and autonomy. And then when it gets onto the merits of the case, the court reiterates all the points about right of access to a court, because he had no possibility of review of this transfer decision. It's very important that everyone has a judicial remedy, an effective judicial remedy, enabling them to assert their civil rights. This decision to transfer the applicant wasn't reviewed, nor was it open to review. And the question before the court, they say, is not whether a particular system of transfer or method of transfer is to be preferred. The question is whether the complete absence of a judicial review of the non-voluntary transfer of a judge is compatible with the rule of law and Article 6.1 of the Convention. And the court stresses the consensus on the necessity to have in place procedural safeguards. And it says what is also at stake is public trust in the functioning of the judiciary. The court concludes that the applicant's lack of access to not do any legitimate aim, and that accordingly the very essence of that right was impaired. See mutatis mutandis, the Bakker case. There has accordingly been a violation of Article 6.1 of the Convention. I'm going to suggest making a break there, and our usual 10-minute break. And when we come back from the break, I'm going to speak very, very briefly about the ongoing Poland-Hungary saga and the conditionality regulation. And then with a very deep breath, particularly because I have had a quick look at the people who are attending this meeting, and they're all very welcome. I am going to try to speak as objectively and dispassionately and academically as I can about something that, for better or worse, has become known as l'affaire Sharpston. So I will see you all in 10 minutes' time.
Thank you, Eleanor.
Emmanuel, est-ce que nous avons les gens sont
pour reprendre après les 10 minutes.
Voilà.
Quand vous êtes prête, tout le monde est reconnecté.
Très bien. Okay, let me move on to look very briefly.
And sorry, Eleanor, just to indicate that there is something on the chat box.
I haven't seen
it. About the Human Rights Act, but it's a. I can read it if you want. It's.
Does the Human Rights Act 1998 still matter in the United Kingdom?
Mm-hmm.
Yes, it does. One of the amusing things, I mean, I say amusing slightly ironically, one of the amusing things that has happened is that for a long time, the European Court of Human Rights was the bête noire of the Eurosceptic press in the UK. And there was a lot of very unpleasant and unfair coverage of the operations of that court. And then we had Brexit and all that. And amusingly, and I say amusingly, but with a slightly sardonic smile, amusingly, what appears to have happened is that the Court of Justice of the European Union has replaced the European Court of Human Rights as being public enemy number one for the Eurosceptic press. Admittedly, a lot of them cannot tell the difference between Luxembourg and Strasbourg, albeit that the two places are separated by about 2,200 kilometers on a map. But they don't actually know the difference between the Human Rights Court and the Court of Justice of the European Union. Still less can they distinguish between the Court of Justice and the General Court. But the pressure, the anti-Europe bile has been spread mainly on the Luxembourg court, and at the moment the Strasbourg court is in relative peace. For how long that will last, I don't know. The Human Rights Act 1998 is the piece of UK legislation that it doesn't exactly incorporate, it half incorporates the European Convention of Human Rights into law in the UK. I say half incorporates because, unlike the situation for EU law, where EU law is imported and until Brexit had the doctrine of supremacy applied, the Human Rights Act 1998 gives a judge power to strike down secondary legislation, a statutory instrument, but a judge cannot strike down an act of parliament on the basis that it violates the European Convention of Human Rights. All the judge can do is to issue what is politely called a declaration of incompatibility, which says, actually, this is incompatible with the convention, but I can't do anything about it. It has had a usefulness, and I'm quoting a friend here who's still doing ECHR work in the UK, and my friend says it's a very useful document. It's the first document that you annex to your application to the Strasbourg court, because you make the application to the Strasbourg court having exhausted remedies at home, and your annex number 1 is the declaration by the UK court saying, actually, yes, this breaches the convention, but there's nothing I can do. That's the answer to the question that came up in the chat. Let me go over very briefly. I'm not going to go into the detail of the Article 7 procedure. I'm going to say something very briefly about Regulation 2020-2092, which is the general ream of conditionality for the protection of the union budget. I'm going to invite you to go away and look at that, and look at the way that that regulation sews together the idea of respect for the rule of law and protection of sound financial management. I just had a look right.
Eleanor, I'll try to invite you again because there seems to have a problem.
Definition in recital 10. We get respect for the rule of law is essential not only for union citizens, but also for business initiatives, innovation, investment, economic, social and territorial cohesion, and the proper functioning of the internal market, which will flourish most where a solid legal and institutional framework is in place. If anyone asks you the question now, why does the rule of law matter? The question I asked at the first session, and people wondered what they could give me. Well, you can find a lot of materials sitting in the front of this regulation. And the regulation says there's a clear relationship between respect for the rule of law and the efficient implementation of the union budget. And then it goes on to explain what's going to be done, breaches of the principle, and so on. And the regulation, the substance of the regulation, then puts in place a mechanism which indicates what the rule of law refers to. That's in the definitions. It identifies typical indicative breaches of the principles of the rule of law. That is in Article 3. Endangering the independence of the judiciary is in there as the first item. failing to prevent, correct or sanction arbitrary or unlawful decisions by public authorities comes in the second item. Limiting the availability and effectiveness of legal remedies, or limiting the effective investigation, prosecution and sanctioning of breaches of law comes in as the third illustration. Then Article 4 speaks of adopting appropriate measures where it is established in accordance with Article 6. Article 6 explains how the procedure operates for deciding whether the conditions for adopting measures are fulfilled. And it's long and you should read it. Appropriate measures shall be taken where it's established that breaches of the principle of the rule of law in a member state affect or seriously risk affecting the sound financial management of the union budget or the protection of the financial interests of the union in a sufficiently direct way. So what is happening is an attempt to use the budget lever, the money lever, in order to enforce respect for the rule of law. The reference for the regulation, thank you in the chat, very helpful. This is Regulation 2020, so 2020/2092 of the Parliament and of the Council on a general regime of conditionality for the protection of the union budget. Thank you very much, Cecilia. I see you've put it up. That's very helpful. And it was the regulation was adopted on the 22nd of December of last year. Before it was adopted, Hungary and Poland issued a joint statement. I've given you the link to it, saying that they are totally unkeen on having such a regulation. I've given you the reference to the Council conclusions, which explain why the regulation is there. And I have also, at the top of page 2 of my handout, I have mentioned that Hungary and Poland have just lodged actions for annulment of that regulation before the Court of Justice. And the court has tweeted, it's nice to see the court in the 21st century tweeting, isn't it? The court has tweeted that these actions for annulment will be allocated case numbers C156/21, that's Hungary's application, and C157/21, that is Poland's application. So those, I suggest to you, are going to be cases to watch. And I'm going to tell you, very sadly, that I am fairly certain that in the course of that, someone acting for either Poland or Hungary, or maybe for both of them, for each of them, may be drawing attention to a slight disconnect between what the court said loud and clear in the Grand Chamber, in Juízes Portugueses and in Commission in Poland, in the passages that I read out to you in the first part of this seminar, and what has happened so far in l'affaire Sharpston. I should also, before I go on to that, let me just tell you that if you want a handy place to find lots and lots and lots of international and Council of Europe materials on the independence of the judiciary and the irremovability of judges, look no further than the judgment of the Grand Chamber in the Backa against Hungary case, which is case application 20261 of 12. The Grand Chamber judgment came out on the 23rd of June 2016, and this handy index to all the international material you might like to refer to on independence of the judiciary and the irremovability of judges is to be found at paragraphs 72 through to 87 of the Grand Chamber judgment in Backa and Hungary. That will save you going all over the internet looking for it elsewhere, because it's a very handy compilation and it's in one place. Something which has always appealed to me as a working barrister for its usefulness. Why go to 15 places if you can find it in one? So, as neutrally as I can, here is what the affaire Sharpston is about. The UK's withdrawal from the European Union on the 31st of January 2020 obviously produced a number of effects. But the question is, what effects did it in fact automatically produce? I set out in the handout, at the annex to the handout, so on page 3, I set out Article 50, Para 3, TEU. That article reads, "The treaties shall cease to apply to the state in question from the date of entry into force of the withdrawal agreement, or failing that, 2 years after the notification referred to in paragraph 2, unless the European Council, in agreement with the member state concerned, unanimously decides to extend this period." And as you will know, there were some extensions, right? But the big question is, what do the words, "the treaties shall cease to apply to the state in question from the date of entry into force of the withdrawal," what do those words mean? What automatically happens and what doesn't automatically happen when a member state withdraws from the European Union? And so, specifically in the affaire Sharpston, did Article 50, Para 3 TEU automatically bring my 6-year mandate, which was due to run until the 6th of October 2021, to a premature end? I had a 6-year mandate, just like everyone else, and it was a mandate that was given to me by all the member states acting together, but it is absolutely true that my name was put forward by the United Kingdom. Is the automatic effect of Article 50, Para 3 to bring my mandate to a premature end? And speaking very much as an academic, I can see that you can run arguments either way. You can say, look, if a state leaves, anyone whom they nominated to a court should also leave. No, it doesn't matter that they're partway through their mandate, they should leave because the state has left. Or you can say, wait a minute, the post that she's occupying hasn't disappeared. The post of judge from the member state will disappear when the judge goes, but the Advocate General's post is not actually attached to a member state. The court's Advocates General aren't like that. The court is assisted by Advocates General. This is all in Article 19 TEU. The court is assisted by Advocates General. And the only link between an Advocate General and the state that nominated them is the fact that there is a political declaration, Declaration 38, annexed to the Treaties of Lisbon, and that declaration records the political agreement between the member states as to which member state has the right to put forward a candidate when there is a vacancy. But that is the only link. And there is case law, even a certain amount of it, to the effect that political declarations and extra treaties do not have binding legal effect. By the way, I have no idea what, as a matter of legal argument, would be said by the defendants, by the member states and the council, in order to explain how it is that Article 50, Para 3 brought my mandate to an end, because they have never been required to lodge observations on the substantive question. They have never, the cases have never got to the stage where they would be required actually to state to a court, here are the reasons why we say that Article 50, para 3 had that automatic effect of terminating her mandate. And the substantive issue has also, you will guess, has never been adjudicated upon by any court or any judicial body. So the substantive legal issue is as I've outlined it, and it's never been decided by a court. We then have a separation of powers issue. That issue is, can the politicians decide what legally Article 50, para 3 TEU did or did not do? Is that something the politicians can decide, or is that something that should be decided by a court? And here I will refer you, and again I put this in the annex, page 3 of my handout, I will refer you to the statute of the court, which is protocol number 3 to the treatise, and which is EU primary law. It's at the same level as the treatise. Article 6 of the statute says, a judge may be deprived of his office or his right to a pension or other benefits in its stead only if, in the unanimous opinion of the judges and advocates general of the Court of Justice, he no longer fulfills the requisite conditions or meets the obligations arising from his office. And there is then a procedure for communicating a decision. And if there is a decision depriving a judge of his office, a vacancy shall arise on the bench once this has all been notified by the president of by the registrar of the court to the European Parliament and to the Commission and to the Council. And then Article 8 says the provisions of Articles 2 to 7 shall apply to the Advocates General. So where Article 6 speaks of a judge, that also applies to an Advocate General. And it is worth recording that I made a formal request to the President of the Court to have the court, under the statute, determine whether Article 50, para 3 had brought my mandate to an end. And I did, in fact, also say, since that is a pure question of law, I will be content if you decide that by a majority. I don't insist on the unanimity protection on deprivation of office, because this could be seen as a disciplinary procedure. And I said, look, I don't insist on the additional protection from unanimity. I will accept the decision, whatever it be, if it's a majority decision, and that will avoid any of this becoming a public problem. And in his administrative capacity, the President of the Court refused that request. So there is a separation of powers issue. And then there is a jurisdictional issue, because appointments to the court are made by the member states. That's how the treaty is set up, so that the member states make the appointment to the court. In the process, the saga of getting rid of me, there were two actions that the member states took. They made a declaration on the 29th of January 2020 that purported to state that my mandate had ended because of Article 50, para 3, and therefore announced that there would be a vacancy, as it were, to be filled, that the Greek government should have the right to nominate somebody to succeed me to take the balance of my mandate, and that Greece would then have a full 6-year mandate behind that. So there was a declaration on the 29th of January 2020. And then on the 2nd of September 2020, there was a decision 2020-1251, which formally nominated my successor, Advocate General Rantos, to take office with effect from the 7th of September. So a decision on the 2nd of September that he would take office with effect from the 7th of September. You will observe that's a rather short timeline. Well, I am humbled to tell you that I have a group of lawyers who have been kind enough to act for me pro bono and who are very good, and we all worked together and we all broke our necks, and we managed to lodge an application with the General Court on the 4th of September, challenging that decision uniquely insofar as it appointed my successor, nothing to do with the rest of it. Challenging that decision, asking for expedition and asking for interim relief. And the application for interim relief went to a very senior and very experienced President of Chamber in the General Court, Judge Anthony Collins, and on the evening of the 4th of September, he made a purely temporary freezing order. The freezing order, which was granted ex parte, had as its sole purpose to maintain the status quo long enough for the other side, the defendants, to put in their observations, and then as the judge dealing with interim relief, presumably Judge Collins would then have had the observations, the submissions from both sides, and he would have taken the matter forward. But the freezing order, I mean, this is not unique. It is a very convenient and entirely appropriate judicial tool for making sure that something irreversible doesn't happen while you're getting in what you need in order to look at the case properly. And I say with very great respect, it was an entirely appropriate, judicial, sensible thing to do. Just, let's freeze it, let's get in the observations, and let's look at this. We need to look at both sides. Let's make sure that we can do that. The next day, which was a Saturday the 5th, the council and the conference appealed that freezing order ex parte to the Court of Justice. Cases C42320PR and C42420PR. They had, by the way, also requested from Judge Collins an extension of time for lodging their observations in response to his freezing order, on the basis that, I think, as I recall, someone was ill and they needed more time to lodge the observations. But what they actually did was to make an appeal to the court. And that appeal was not notified to my lawyers or to myself. That was the 5th of September. And then on the 10th of September, which is the Thursday of the following week, the Vice President of the Court signed ex parte orders allowing the appeals, dismissing the entire application for interim measures, and expressing the view that prima facie the General Court had no jurisdiction to entertain the two actions involving the member states. And at that moment, Advocate General Rantos became Advocate General Rantos. There was an impromptu ceremony and he was sworn in. Once he had been sworn in, the Vice President's orders, together with the texts of the actual appeals, which they decided, were notified to my lawyers. On the 6th of October, the actions before the General Court were dismissed by reasoned order. The General Court aligned its reasoning on what it had been told by the Vice President and dismissed the cases. There were 3 cases before the General Court, because there was the case against the declaration of the 29th of January, T180/20. There was a purely precautionary action brought against the letter that the President wrote notifying the vacancy, and that's T184/20. And then there was the challenge to the decision appointing Advocate General Rantos, T550/20. The 2 orders involving the member states, so the 2 orders in T180/20 and T550/20 have been appealed to the Court of Justice. The case numbers for the appeals are C684/20 and C685/20. And those cases are now pending before the Court of Justice. I am going to offer you a very much an academic statement, and I do emphasize it's academic because I do not know what the court is going to do with the case. It seems to me as an academic that there are 2 things the court could do, either of which would go a long way to repairing the damage that has been done, I suggest, to the rule of law by what has happened so far. One option would be for the court to accept that it does have jurisdiction. It could do that by applying the Lever line of case law. The action of the member states making an appointment to the court is an action by the member states, but it is an action which produces all its effects within the EU legal order, because a member of the court is acting within the EU legal order once appointed. And it's also an action which in the present instance had an adverse effect on a third party, your humble servant, within the EU legal order. So you could get to accepting jurisdiction by applying Lever and the thinking behind Lever. And you could then go on to look at the substance. And if you were to do that, whatever were to be the outcome on the substance, I would be perfectly content. I would say this is a victory for the rule of law. On the substance, you can have 2 views. If they were to decide the substance against me, I would obviously be disappointed. But of course, you can have 2 views on the substance. You can have 2 views on most legal questions. And importantly, the decision as to what was the legal effect of Article 50, Para 3 would have been taken by a court, not by the politicians, but by a court. I should also perhaps interject there that I have made it very clear in the appeals, I'm not looking for financial compensation. I am not expecting to be reinstated, because I don't think that's a plausible expectation. And I have also suggested that the court, were it to accept jurisdiction and decide in my favour, should use its power, which it has under the treaty, to state that certain of the effects of the invalid act on this hypothesis should be maintained, so that nothing that happens in these proceedings upsets what my successor, Advocate General Rantos, is doing at the moment by way of sitting in cases, giving opinions and so on. In other words, I'm not, as we say in English, I'm not trying to upset the apple cart. I'm not trying to be disruptive. I am simply trying to reassert the rule of law. So the first option would be that the court took jurisdiction. And if it were going to do that, it would have to do so in a big formation of court. You know, it would presumably have to be a decision of the Grand Chamber. The second possible option, as it seems to me, and again, I would understand this as a plausible answer, would be that again in a large formation of court, the court said, look, we see the problem. We see that there is an issue about the rule of law, and we see that there is a structural defect because we don't think we can intervene, we don't think we can take jurisdiction, but we see the consequence of the fact that we don't have jurisdiction is that the political actors can at will remove a serving member of the court. And that's not very good. That's not good for the rule of law. And therefore, we request the member states to go and fix the problem by changing the arrangements so that we as a court really do have the kind of independence which we have been saying that a court tasked with deciding questions of EU law should have, because these proceedings have shown up the crack in the system. They've shown that there is a problem. And we don't think that we can be bold enough to take jurisdiction, but we do think that there's a problem and the member states should fix it. That would itself, I suggest to you, be a helpful move towards repairing damage to the rule of law. The third possibility is to use the jargon of the court, on va sortir cette affaire par la petite porte. And what you do is you adopt a reasoned order, you try to keep the case as small as possible, and you adopt a reasoned order which presumably would echo, perhaps elaborating, who knows, the reasoning of the Vice President's ex parte order, and you dismiss the appeals. I think I should probably conclude there by one last sentence, which would say it might be that the affaire Sharpston, depending on what the outcome is, it might be that the affaire Sharpston doesn't stop in Luxembourg. It might end up down the road in Strasbourg. I hope very much that it won't end up down the road in Strasbourg, because as somebody who served the court for 14.5 years, I am upset by the fact that at the moment, the situation gives free ammunition to Poland and to Hungary to point out what they would call the hypocrisy of the courts in saying to Poland, in Commission Poland,
I hope this is not censorship from our part. I'm just gonna recall Eleanor Sharpston in order for her to end with her speech. So please be patient. This happened also yesterday when we were not speaking about the Sharpston case. So
I see that the internet has a wonderful sense of dramatic timing. That was impressive. That was spectacularly good.
Yeah.
That was really very funny, but I had actually finished because, I mean, unfortunately, and this is not my observation, Poland has already started citing the affaire Sharpston as being evidence of the court being hypocritical, and that really saddens me and hurts me, because they shouldn't be able to have that ammunition.
Eleanor, do you?
Oui, je vois dans le chat, oui. La réponse à la question, c'est que le livre, je ne l'ai pas encore écrit, hein, j'étais très honoré d'être invité à présenter ce cycle de conférences. Et effectivement, j'ai investi pour rassembler ce que je vous ai dans ce cycle. Dans mon, comment dirais-je, dans mon agenda, ma programmation de mon travail pour l'année à venir, j'ai d'emblée que je dois écrire le livre des Hamlin Lectures que j'ai donné aux trois grands discours au cours de l'automne. The Hamlin Lectures are actually about the great experiment constructing a European Union under the rule of law from a group of diverse sovereign states. And if anyone's interested, you can, if you go to the website of Exeter University, all of them, of course, were online because of the pandemic. And so actually they are all accessible online. I will maybe send to Professor Barbosa the link in case anyone wants to follow up on that. But once they have actually written up the Hamlin Lectures and given that manuscript to Cambridge University Press, because they are publishing the lectures as a monograph, if anyone thinks that there might be an interest in having this sequence written up, that could be something that I could be persuaded fairly easily to have as a further project. I mean, I am, of course, at the moment technically unemployed, right? I mean, I've just lost my job on the 10th of September, and oh, that's kind. Somebody's put something very nice in the chat. Thank you. Oh, and that was quick with the Hamlin Lectures. Wow, somebody is really quick on the draw. Thank you for that. So further because this is our last session together, I'm so sorry this is on Virtuella, because we would naturally get together after the last one and we would talk more and so on. Are there additional? I know Professor Barbosa, I know you have to go. Please do feel free to go when you know, and thank you so much for presiding this one. Are there other questions that people would like to ask?
There are some questions in the chat, I see.
Yeah, the question on the chat is a very sensible question. If we talk about Strasbourg, we have, of course, in Strasbourg, we have the Bosphorus decision, which has a presumption in it that EU law, as interpreted by the Court of Justice, complies with the Convention rights, but it is a rebuttable presumption. I stress the word rebuttable. If we try, I mean, this is a little bit hypothetical, right? Because you have to hypothesize what would be the basis on which the court said that it wasn't going to decide the case. If it decides the substance, it decides the substance, and that's fine, and that's the end of the story, right? But if it doesn't decide the substance, what is its basis for not deciding the substance? Is it going to say, we don't have jurisdiction? Well, if it says we don't have jurisdiction, what it is saying is we have actions by the member states within the scope of EU law that impact within EU law, which, on my argument, violate the right of access to a court, because I can't get a court to decide the substantive issue. I can't get in through the door. And that action, according to the court, is attributable to the member states. Well, if you have that, then presumably the member states who are signatories to the convention have a responsibility for what happens within the scope of EU law, where the Court of Justice has just explained that it can't do anything because this is all up to the member states. But the end result is that you have somebody who loses the opportunity to serve the rest of their mandate. And, you know, yes, obviously you get paid for serving and so on, right? So a civic right, I lose the chance to serve the rest of my mandate, and there is no court I can go to. I can't go to a court. I did make some efforts to find out whether, for example, I could go to an administrative court in Luxembourg, and the answer is, of course not, because this is an EU decision made by the member states, all acting together, appointing to the court. I mean, for those who are interested in interesting developments in the case law, it will be fascinating. I have to say, you know, speaking as a pure academic, gosh, how interesting. It would be really nice not to have to go there, because it would be really nice to have the court recognize that it needs to say something to repair the damage to the rule of law. Whether it will do that, I do not know. But I do suggest to you that what I have described to you as a chain of events does not sit very comfortably with what the court said in the Grand Chamber in Commission against Poland and in Juicios Portugueses. You know, I think to say it looks like there might be a problem here is not an overstatement. It is perhaps a British understatement. Cecilia, are you chairing? Because there is somebody has got a hand up.
Yes, of course, yes. So I see that there are also other questions in the chat, but I will just... Sorry, I don't see the name of the people. 1 second. Yes. So there is Johan Mardi, who can maybe take the floor for his question. Ah, he just disappeared.
Oui, oui, bonjour.
Ah, voilà.
Oui, bonjour. Voilà, je suis étudiant à l'ULB. Ma question concernait la conditionnalité budgétaire. Alors, c'est pour savoir si vous pensiez que ce nouveau mécanisme qui donc vise le blocage de fonds européens et qui donc cette fois-ci touche à des ressources financières des États, va-t-il avoir un impact réellement significatif sur l'attitude de certaines politiques comme celle par exemple menée en Pologne, d'autant plus que si je ne me trompe pas, la Pologne est également l'un des plus grands bénéficiaires du budget européen. Ou alors, est-ce que selon vous, cela ne constitue pas vraiment un instrument suffisamment dissuasif à lui seul et il faut le voir donc comme un instrument complémentaire?
Sans doute les personnes qui ont conçu le mécanisme qui est instauré par ce règlement espèrent que ça va aider, que ça va marcher, si je peux me faire mettre le mot, que ça va aider. Je me permets de dire, je vais prendre l'analogie de la boîte à outils. Hein? Tout artisan a pour son travail une boîte à outils qui contient de différents outils. Et lorsqu'on se trouve, on a quelque chose à faire, n'est-ce pas? On regarde le problème et puis on ouvre sa boîte et on sort un outil de la boîte. Et on commence à voir si ça peut marcher avec cet outil-là. Et si on constate que ça ne bouge absolument pas, bon, on va mettre l'outil là de côté et on va prendre un autre outil, ou on va bricoler pour fabriquer un autre outil. Ou éventuellement, on va se servir de plusieurs outils pour essayer s'il y a un vis à débloquer ou un boulon qui ne veut pas lâcher, on essaie, on fait de son mieux. Et pour moi, le droit, peut-être c'est une réponse très imprécise que je suis en train de vous donner, mais pour moi, en tant que praticienne, le droit a toujours été un peu comme ça. Je regarde quels sont les outils que j'ai dans ma boîte. Et si quelqu'un veut bien ajouter un outil aux outils que j'ai déjà dans ma boîte, je suis toujours contente. Parce que comme ça, j'ai de plus amples possibilités pour arriver au but souhaité. Rien ne garantit que tel outil va fonctionner mieux que les autres, mais si j'ai des outils supplémentaires, en règle générale, c'est quand même un ajout positif. Et j'ai un peu ce réflexe vis-à-vis du règlement. Je sais que le règlement, d'ailleurs, on a déjà critiqué ce règlement sur le Verfassungsblog. Il y a déjà une critique qui dit, mais qu'est-ce que ça fait? Pourquoi ne pas poursuivre avec l'article 7 TUE? On a déjà un très, très grand outil, on va dire plutôt l'arme nucléaire, n'est-ce pas? Pourquoi ne pas tout simplement continuer avec ça? Pourquoi bricoler avec un règlement qui vise le bon fonctionnement sur le plan financier de l'Union, mais où on essaye par le biais de cela de régler un problème de l'état de droit. Et je comprends, mais là, pour moi, même si éventuellement c'est une critique valable, c'est une approche quand même très, très puriste. Moi, je suis très pragmatique. C'est peut-être le seul aspect en moi qui soit vraiment britannique. Je suis absolument pragmatique. Si j'ai plusieurs outils, tant mieux. Ça va me permettre d'essayer de débloquer la situation.
Ça va, merci beaucoup.
Mais je vous en prie.
Est-ce qu'il y a d'autres questions? Or are there other questions? No?
Il y avait une question dans le chat, moyen de rester en contact. Et effectivement, ce qui est très, très gentil de la part de la personne qui l'a écrit. Effectivement, professeur Bribosia a mes coordonnées. Hein, et bon, je ne sais pas, il se peut que j'ai un peu compris ces gentils mots en ce sens que mes liens avec l'Université libre de Bruxelles probablement ne vont pas terminer aujourd'hui à midi. Donc, il y aura moyen, je crois, de rester en contact.
Bien sûr. Si... Isabelle, tu veux...
Oui, je voulais juste vérifier s'il n'y avait plus d'autres questions. Donc, I don't have a question. I just wanted to check with students if they were fine. And I can say that it's for sure Professor Sharpston will be invited in Brussels at the ULB, and so there will be other opportunities to stay in touch and to learn more.
You are very, very kind. In that case, we should probably bring this webinar to a close before my internet falls over again or my dog eats the cable. My dogs have been very good, but they're getting a little impatient. It has been a pleasure teaching for you. Thank you for your willingness to engage with me and to engage with a different teaching style. I greatly appreciate your willingness to do that. And I wish all of you the very best. Above all, I'm going to say to you, stay safe, stay well, be careful, look after yourselves and your loved ones, and I wish you all the very best. Yes?
Many thanks, Eleanor. I think that everyone enjoyed very much. We see in the chat box many people are saying thank you. I think we really enjoyed this.
Thank you too.
And also the interactive character of that. Even if we are not very used to it in Belgium, I think it's a very, very good way of teaching and especially when we are doing that online. It was not tiring at all, and we learned a lot, I think. And now I see all the messages on the chat box.
There are some very kind messages in the chat box.
Yes.
Please thank everyone from me. Yeah,
and we thank you very much. And as Emmanuel and Isabel said, we really hope to see you in Brussels very soon, and to invite you and to welcome you physically. And
that would be, I will say yes to that for all of us.
Yes, and
thank
to
you,
stay in touch for sure.
Okay.
Thank you very much. Stay safe.
Take care.
Thank you, Eleanor. See you soon.
Bye-bye.
Thank you. Bye.